This debrief is Essay 2 from the Feb 2023 California Bar Exam, Constitutional Law Essay, with 2 calls. One major call that's wide open, and a second call that is about association standing. Again, please help us out. If you find value in this content, then do the usual YouTube things. Subscribe, like the video, comment below, and tell us what else you would like to see. And in particular, whether you would like us to start building a Patreon channel where we could interact directly. Let's take a look at question 2 from the February 2023 bar exam in California. As always, I try to quickly figure out what the subject is so that I will have my concise outline of that subject in my mind as I read the facts. So I see 2 calls. First call, what constitutional challenges can the Attorney General make to the Act, and are they likely to succeed? Discuss. Straight constitutional law, wide open call. Anything in the Constitution. So, call 2, does NASD have standing to intervene? NASD sounds like the abbreviation for the name of an organization, and so I assume this is association standing. Standing is rarely a big issue in a con law fact pattern unless the California Bar has a call that asks you about it, and here they do. And they very rarely ask about plain vanilla standing. When they ask about it, it's generally association standing or third party standing. Before we move on to the hypothetical, let's talk about what I meant when I said I need to have my concise outline in mind when I spot the hypothetical. Let's take a look at the kind of concise outline I would have in constitutional law, which helps me spot the issues. When faced with a wide open call like this in constitutional law, I have in mind the fact that the branch of government committing this act needs to have the power to do it. I'm thinking about whether there's a conflict between federal law and state law, which is the issue of federalism. I'm thinking about whether there is state action involved and whether the due process clause, either procedural or substantive, would be triggered. I'm thinking about eminent domain, equal protection, First Amendment. And I think those calls raise judicial power and legislative power. Under judicial power, in my organization, I have standing, I have ripeness, and I think either of those may be involved. Mootness generally will have its own call, but standing and ripeness may be issues. So I have the law in mind for ripeness, and I know that I think this probably involves association standing. So of course, I also have all I need to know about association standing in mind as I read this hypothetical. I said the California Bar rarely tests regular plain vanilla standing. Why should they, when in order to prove association standing or third party standing, you have to, within that analysis, analyze the basic elements of standing anyway, because you have to prove for association standing that a member of the association would have standing to sue. And then, of course, you have to also prove that the interest asserted is germane to the association's purpose and that an individual wouldn't have to sue on their own behalf because there aren't a plethora of individualized damages. Okay, so that law is in my mind when I go back to read this hypothetical. But of course, I also have to keep in mind the law that tells me whether Congress had the authority, whether the legislature had the power to pass this law in the first place. That's a Commerce Clause analysis, and that means that I have to at least briefly tell the grader what the commerce power involves. I have to give the reader the general rule. I have to analyze whether this involves the instrumentalities of interstate commerce, because Congress has plenary power over all of the channels and instrumentalities of interstate commerce. And so far, I haven't seen that anything like that is involved. This looks to me, from the call and from the first paragraph, like an intrastate regulation. And so I need to decide whether it's commercial or non-commercial, economic versus non-economic. If it were an economic or commercial regulation, it would be the substantial effects test. But I think this is non-commercial. And I think that Congress will lack authority unless it has an articulated rational basis to believe that the regulated activity has a substantial effect on interstate commerce. Right now, without going further in the hypothetical, it looks like I can use the fact that the funds are to be used for the purchase of physical education equipment to make that argument. But anytime I think about commerce power, I also need to think about the limitations on this kind of commerce power, this non-economic commerce power. And one of the big limitations is commandeering. Congress may not compel states to legislate in a prescribed fashion. I don't know whether that's coming up yet or not, but I'm on the lookout for it. That's what this kind of final outline does for me. It alerts me to be on the lookout for commandeering and also for unknown liability. Would I raise 10th Amendment? Yeah, probably. Will it work? Probably not, but I'd raise it anyway. And I don't know what other constitutional claims I could raise until I get further into the fact pattern, but I'm on the lookout for more. All right, what do we have in the hypothetical? We have, in response to a significant rise in diabetes among school-age children, and based upon links between diabetes, exercise, and diet, Congress has passed and the President has signed the Childhood Physical Education Act. The act, administered by the Federal Department of Education, provides significant additional funds to states for public schools with daily physical education classes for students. These funds are to be used for the hiring of additional physical education teachers and purchase of physical education equipment. Okay, they've given us the government interest. They've also basically told us that the federal government, the legislature, can pass this kind of an act because of the Commerce Clause. They tell us that it's for purchase of physical education equipment, which is going to allow us to argue that this will have a substantial effect on interstate commerce, because not every state manufactures physical education equipment. There's going to be interstate commerce involved here. And the interest appears to be pretty compelling, right? Congress is legislating in the area of health and safety. That's generally reserved to the states, right? So can they use the 10th Amendment to say Congress can't do this? Probably not. And while I highlight this, the rest of this paragraph, let's talk about what I wrote down below. I should have done that earlier on. I wrote in there 35 minutes for call 1 and less than 10 minutes for call 2. When I read calls, often I have a good idea what my time allocation is going to be. This is a 1-hour essay, and so by the time I've issue spotted it, I have about 45 minutes to write. That is how I would allocate my time, because association standing is much faster to analyze than all the constitutional claims the Attorney General can raise in call 1. I keep that timing in mind as I go on with the hypothetical. If I need to adjust it, I will, but right now, that's what it looks like to me. So let's go on with the hypothetical. Testimony before Congress has revealed that on average, public schools spend only 25% of their school lunch budgets on fresh fruits and vegetables. The act requires that states accepting the funds must enact legislation setting as a minimum that 50% of public school lunch food budgets be allocated to the purchase of fresh fruits and vegetables. Aha! Here they give us the limitation on the commerce power, commandeering the state legislature. Congress cannot commandeer the state legislature. They can't tell a state how they must legislate. They can use the power of the purse to try to get the state to do what they want. So they could have framed this act in terms of any state applying for funds will be eligible only if they can document that 50% of their budget goes to fresh fruits and vegetables. But they can't tell the state, in order to get the funds, you have to pass this particular legislation. So paragraph 1 raised the commerce power. Paragraph 2 gave you a way to fight the commerce power. Now paragraph 3 says testimony has also revealed that rates of childhood diabetes tend to be highest in minority and low-income communities. The act has significant additional subsidies for public schools where the majority of the student population is non-Caucasian. I think that paragraph gives me other claims I can raise. How about equal protection? Public school versus private school would be a rational basis review. What about the majority Caucasian versus the majority non-Caucasian? Would that be a race-based classification? What do you think? And if it is, would the state attorney general have the standing to raise that claim? That would mean strict scrutiny review. They gave us a compelling government interest. Is it narrowly tailored? Go on to paragraph 3. Before the act has gone into effect, State X, through its Attorney General, has brought suit in federal court seeking a declaratory judgment that the act is unconstitutional. That raises the issue of ripeness for me. I'm going to find that this is ripe. The National Association of School Dietitians is seeking to intervene in the Attorney General's lawsuit. There you have it. Association standing is the issue. According to NASD's charter, it seeks to promote healthy diets for school-age children, especially through school lunch programs. There's the association purpose. Is this germane to the association purpose? And would an individual member of the association have standing to sue? Looks like they would not be asking for damages. They'd simply be trying to block the Attorney General from getting a declaratory judgment against the law, meaning that individual members wouldn't have to sue on their own because there are no particularized kinds of damages. That's what I see when I issue spot this hypothetical. Did you find more issues than that? Do you find other claims that could be raised in opposition to this law? I think what I most want to say to you in the end of this is to take control over what happens when you go to an essay in a law school exam or a bar exam. Don't approach it thinking, oh, I hope I see the issues. Approach it knowing that you have a good, strong, coherent outline memorized and in your mind, and that it will guide you in spotting all the issues.